Hello friends, good afternoon and welcome to the EduSat Network. Our topic of discussion is fundamental rights in India. And friends, since it is a continuation from our previous lecture that happened yesterday, this is going to be part 2 of fundamental rights in India. And friends, to throw more light on the idea and to give us a lecture, we have with us our same subject expert, Dr. Satish Kumar Jha, Associate Professor, Department of Political Science, Aryabhatta College, University of Delhi. Sir has been teaching political science for more than 2 decades, and with this very brief introduction, I welcome Sir to the studio. Sir, thank you so much for coming today, and I request you to begin the lecture today.
Thank you, Dr. Urvasi. In fact, today's lecture is in continuation with what we were discussing yesterday, that was fundamental rights part 1. What we did yesterday was to just see that how this entire discourse of rights has evolved in India and how this constitution reflects that long tradition of that quest for rights, particularly which started in modern times during colonial period, and finally it got telescoped into this entire structure of rights which we basically find in the constitutional scheme of things in India for last 6 decades and so. Now, these fundamental rights we were discussing, of course, is not totally in fact a new thing so far as this constitutional history of the world is concerned, because United States of America, as we discussed, was perhaps the first instance where a written constitution tried to incorporate these rights of the people. But what we are also discussing, that Indian situation is different and also to some extent significant, because India has tried to combine a lot of experiences and lot of basically in fact advantages which have been given by history in terms of the later period in which India was basically drafting its constitution. So, what happened that we have combined the best of perhaps the all existing systems, and therefore, Indian constitution, particularly the entire chapter on fundamental rights, stands out as one of perhaps most noble experiment in this domain. So much so that I was discussing yesterday that how political theory only in 80s and 90s started recognizing the importance of group rights, but Indian constitution, when it was drafting fundamental rights, basically tried to harmonize group rights with the individual rights and making it somewhat totally a new experiment. So, this way it is not only in terms of harmonizing individual and group right, but there are many other provisions which also stand out in terms of a very wide and far reaching provisions in terms of affirmative action, what is basically normally understood as positive discrimination in Indian situation, as well as the way the secularism of course has been basically incorporated, the provision of secularism has been incorporated in the constitution, and fundamental rights chapter perhaps it was the most important chapter where we find the reflection of that secular principle without having used the term secular. In fact, most of the cardinal principles or those principles through which a secular polity is basically understood and interpreted, we find those principles find space in the fundamental rights section of the constitution. We will basically come to this issue, because the freedom of religion is very important component of these fundamental rights, particularly as it is guaranteed in Article 25, along with the principle of disestablishment which separates the religion from the state. In fact, another important principle of secularism we also find taking shape in Indian constitution. Similarly, the principle of equality, the principle of non-discrimination, two important basically principles of secularism we find that have important place in the fundamental rights section of the constitution. So, in fact, what is interesting to see that on the one hand you have secularism, on the other hand you have social justice, the positive discrimination, affirmative action program, all these things coexisting side by side, and thereby making this a very unique document, where in fact in the same breath both secularism and social justice have been talked of. And today we find there are a lot of theoretical advancements have been made in political theory and political philosophy, where basically for creating a non-discrimination based society, some sort of positive discrimination is also advocated, particularly thinkers like John Rawls and others in political theory have been advocating this line of argument. And therefore, in India we find that the similar arrangement has been made. For example, in article 15 of the fundamental rights and article 16 of the fundamental rights, two best examples that how this non-discrimination, that is 15, and then you have this whole scheme of positive discrimination in 16, of course as per the original constitution, but later on even the 15 was amended and 15(4) was added. But nonetheless, even if we go by the original scheme of things, then we find that 15 and 16 exist side by side. So, 15 if we interpret as an article advocating non-discrimination and thereby secularism, and 16 advocating positive discrimination. So, secularism and social justice coexisting side by side. So, I mean this way we find that number of important interesting features of political theory, or basically one can say that some of the values of democracy are basically getting reflected through the fundamental rights section of the Indian constitution. So, this is what we are trying to make sense of in our previous lecture. We also try to see that how this evolution of the right discourse in India to great extent is also indigenous. One cannot say that it is totally derivative, that only inspiration was United States of America, or for that matter what happened in Europe, whether through French Revolution or some other revolutionary moments in Britain and other places. But also we find that there are many similar churnings taking place in India itself, and therefore we saw that how from time to time important documents came into circulation, starting with 1894 the Swaraj act of associated with Tilak, then Annie Besant, and then various Congress resolutions, and finally this 1946 when the Constituent Assembly met and decided to incorporate whole set of rights as fundamental rights in the constitution. So, this is how we have to understand this entire discourse of rights in India. Then you also said that Indian fundamental rights have certain special features, and we are trying to basically find out those features in our previous lecture. For example, there are rights which are available only to citizens, but there are also rights which are basically universal in nature and available to anyone who is on Indian soil. So, that way we can say that there is a provision for human rights, even rights available for alien and not only citizens. Similarly, we said that there are rights which are universal, it had universal applicability, but then the rights are also fundamental rights are also restricted in certain situation. Of course, the most well known provision is emergency provision in the constitution, when basically rights are suspended. But even in otherwise, there is article 33 which basically limits the application of rights particularly to the army personnel, and therefore this restriction is very much there. Similarly, we also discussed that how the rights are absolute to some extent, but as we also saw that how Ambedkar himself said that there is no instance in the entire constitutional history of mankind where rights have been understood purely in absolute terms. Always rights are accompanied with certain restrictions, the reasonable restrictions. United States of America, those restrictions have been left for the judiciary to impose, but in India the Constituent Assembly decided that those restrictions have to be recorded and mentioned in black and white in the constitution itself, so that the judiciary does not get ample space to basically to interpret in a subjective manner, and therefore constitution has many restrictions prescribed along with those rights. So, I mean absolute, at the same time they are also limited, as we have earlier mentioned that individual and the group rights existing side by side. Similarly, you also saw that some rights are against the state, most of the rights are rather against the state, but then there are certain rights against individuals also, particularly article 17 when the untouchability has been abolished. So, therefore, in fact these are some important characteristics of these fundamental rights which we are discussing in context of Indian constitution. Then of course, we also discuss and that is also quite significant, that normally it is believed that fundamental rights exist in the part 3 of the constitution, but then there are also rights which exist outside this part, and they are equally important, though in fact one thing is significant, that those rights which are available in part 3 in fact the Supreme Court can basically provide protection to those rights under Article 32, and therefore it is a special in the sense that the remedies lie with the Supreme Court. In fact, one does not have to go to the High Court and then come to Supreme Court in appeal, but straight away one can move to Supreme Court, and Supreme Court will be duty bound to issue writs under Article 32, the prerogative writs which we were referring to earlier. But there are rights which are outside of this part, that is part 3 of the Constitution. For example, in fact you have 300A, then you have 301. For example, 300A is basically this authority of law. I mean, this is related to property, because as I was also mentioning that under 44th Amendment, the right to property which was there in 31 was shifted from fundamental right chapter to this 300A, and therefore now it is no longer a fundamental right, but it is a legal right, and therefore this remedies or the protection now available under 226 the High Court, and therefore it is now not a fundamental right, but nonetheless it stands as a right of the citizens. Similarly, 301, the freedom to do trade and commerce, is another important right, but it is not a fundamental right, but it is there as a right existing outside this part 3, and all these rights of course have protection of both High Court and the Supreme Court, and the Supreme Court has a concurrent jurisdiction along with the High Court, but of course the remedies initially lies with the High Court under 226. So therefore this is something quite significant. Now of course we also should remember that the scope of these fundamental rights, in the sense that of course they are likely to be amended, because a situation came when I mentioned that in famous Golaknath case, it was argued by the it was rather advocated by the Supreme Court that fundamental rights are so sacrosanct that they cannot be amended, and if there is any need for amendment, then another Constituent Assembly will have to be convened. But that position was revisited in Keshwanand Bharti case, and after Keshwanand Bharti now we stand in at a situation where the fundamental, any part of the Constitution including fundamental rights can be amended, but only basically rider is that the basic structure should not be disturbed or cannot be disturbed, and that basic structure, as I was mentioning, is totally undefined, but from time to time now Supreme Court has started giving hints that what constitutes the basic structure. For example, parliamentary democracy, in that famous case when some members of parliament were alleged to have taken bribe for bailing out a government, and then matter reached to the door of the Supreme Court, and the Supreme Court adjudicated on that matter, and basically while adjudicating also stated that parliamentary democracy is one of the basic structure of the Constitution. And similarly, federalism, secularism, from time to time the Supreme Court has been trying to basically expand this list of basic structure, and therefore now we have some idea that what constitutes the basic structure, but still there is no definitive interpretation of basic structure. So amendment, yes, fundamental rights, so for that one any part of the Constitution can be amended, but the rider is the basic structure of the Constitution. And therefore we find that using this amending power, the Parliament has amended the Constitution, particularly the fundamental rights, and there are many significant amendments, and of course there are whole host of amendments which have been made in fundamental rights section, but 25th amendment of 1971, particularly when this fight was taking place between directive principles and the fundamental rights, and as recent as 2002 86th amendment, when Article 45 was transferred from directive principles as a state policy and was inserted at Article 21A, that free and compulsory primary education till age of 14, basically right to life. So education has been included as 21A in this provision of right to life. So life, the definition of life has been expanded. That life does not mean simply animal life, animal needs of the people, but rather that life, as I will discuss later, because this Supreme Court's creative interpretation of various fundamental rights has also led to expansion of the meaning and scope of fundamental rights. And one of the most creative and constructive interpretation has been on this issue of life, that what does this life mean, and now the life is expanded the definition of life has been expanded in a manner where of course dignity constitutes life, now education constitutes life, and so on and so forth. And now with this amendment we find the right to education, the free and compulsory education becoming part of this article 21A, which is basically originally stands for right to life. So therefore, this is something we should remember so far as the amendment of the constitution is concerned. Now of course, we are also trying to have a look at the comparison between India and USA, and we discussed that how American and Indian experiments are different. Of course, United States of America, in fact, they were incorporated through the first 10 amendments, but in India of course, they are part and parcel of the original design of the constitution. Even in terms of restrictions and the limitations on rights, United States of America, the Supreme Court has from time to time come out with their prescriptions of basically limitations and restrictions, but in India we find that restrictions have been recorded in black and white in the constitution itself. So this is how we have to make sense of this entire scheme of things known as constitution of fundamental rights in the constitution of India. Now if we come to the basically the details of these rights, then we find that there are 6 different types of rights. Of course originally there were 7, but this right to property no longer stands as fundamental rights. So finally they are left with 6. So I mean the first important type is right to equality, and this is a very important right, because as this is the cornerstone of any democratic polity. Without equality, in fact, democracy cannot be thought of or imagined. So right to equality, and this starts with article 14 and basically continues till 14, 15, 16. Basically these are the provisions which are dealing with equality. Now 14 is of course a generic, is phrased in a generic terms, and that is basically a broader principle of equality, equality before law. I mean this basically entire rule of law principle one can say exists there. And then finally you have article 15 which talks of non-discrimination, and then article 16 which talks of equality of opportunity, and then finally 17 which tries to end untouchability, big problem of traditional Hindu society, and therefore trying to create equitable social and economic situation, and therefore that is there. And finally 18 basically end of this title system of titles, giving titles and therefore creating hierarchies and privileges. So basically it is also an attempt to level all citizens, in the sense that there will be no abolition of titles, means there will be no privileged position in terms of having some superior status in the society. So from 14 to 18 we find that all these provisions, all these articles are meant to create a equitable social, political and economic situation in India. Now after equality we move to liberty, freedom, and that starts with 19, where basically you have extensive list of freedom, different types of freedom, and then of course there is one freedom of course there which is no longer there, that is property, which was 19F, but still the other freedoms continue to be there. And then you have 20, then you have 21, and all these are basically related to freedom and liberty, particularly about detention, about right to life, that no one can be deprived of his life and liberty without but even if there is a situation where that is being done, then it can be done only according to the procedure established by law. So therefore it is a right against executive, not legislature. But if legislature lays down the procedure through which people and citizens can be deprived of this right, then of course that will be valid. But till that time that procedure is not laid down, then one is having absolute right to life and liberty. So procedure established by law, and I was referring to this procedure and due process thing. United States of America, of course you do not have the procedure established by law provision, but rather you have due process. And when it says due process, then that gives ample space to judiciary to basically interpret on basis of natural rights and natural justice. But unlike United States of America, it is not this natural rights, natural justice based procedure, that is a due process. Here it is procedure established by law, and so therefore, it is a procedural thing is basically prescribed, not the substantive thing, but the procedural thing. So, substantive justice is not basically the part of this, but a procedural justice. But I was also mentioning that how the Supreme Court has from time to time expressed its mind, and now more or less one can say that so far this procedure established by law is there in the Constitution, but so far as in practice it has moved very close to what we normally understand by due process United States of America. And due process, as I was mentioning, natural rights, natural justice, and the same things are being now invoked by Indian judiciary to basically expand this ambit of liberty, right to life and other things. So, this is another type, that is liberty. So, after equality we have liberty of freedom, and the third of course is right against exploitation, and this is another very important provision of the Constitution. So, fundamental rights are concerned, and here you have basically article 23, 24, and particularly these two important provisions are there, because the 23 is the forced labor and 24 is the child labor, and the Indian situation of course demanded these provisions, because first of all India was reeling under colonial rule, and number two, Indian society was hierarchical society, a feudal society, and therefore there were different types of labor practices, and some practices were basically the forced labor, indentured labor, and therefore what happened, that it was required that the constitutional provision should be incorporated under which some such labor practices should be abolished and people should enjoy their freedom, and therefore it abolished forced labor under 23. It abolished child labor under article 24. Interestingly, article 24, the child labor is absolute right, there is no restriction imposed on this article, unlike all other articles where you find that some restriction or the other is there. But this prohibiting child labor in factories and other places, this is absolute right, basically there is no restriction, no limitation on this right. Then of course traffic in human beings and so on and so forth. So, this way this is a right against exploitation, and this is another significant provision of the fundamental rights. And the basically then the fourth one is the freedom of religion, and this is equally important thing. As I was mentioning, that entire basically basis for secularism in India emanates from some of these provisions, along with of course 14, that is right to equality, 15 non-discrimination, because equality and non-discrimination are equally important for a secular polity. But this basically article 25, which gives freedom of religion and conscience to practice, propagate and profess religion, I think this is perhaps what is called freedom of religion, religious liberty. This is very important right today in today's world. Basically secularism does not imply that religion does not have any role to play in people's life. Today it is growingly understood and accepted that without giving this freedom to the people, no society can truly be secular, because banishing religion is no solution. For example, of course we have many instances where attempts were made to banish religion, but then we also saw that how in a private sphere it kept it was alive, and at times it used to spill over to the public sphere, and therefore people also revolted against it, and then of course this banishing religion from society, that strategy did not work. So, basically only those polities or those societies where you have this freedom of religion, or one can say the equal respect for all religion, there is equality and non-discrimination, that one can say that truly secular polity can take root, and India is perhaps the best example where we find that this freedom of religion has been guaranteed. Of course, this propagate and practice, these two things are important here, and they have also they have been the matter of debate and discussion, because what does this propagate means, and therefore in India we find that quite often this entire controversy on conversion from one religion to another comes up, and that creates a kind of social turmoil, but nonetheless this is part of this basically article. Of course, there is a context and that the context should be seen in terms of incorporation of this provision in the constitution when the constitution was being drafted, particularly the Christian minorities, because for them basically practice of religion included this basically the art of propagation of their religious teachings and religious values, and therefore they demanded that without giving this right to them, their freedom, religious freedom would remain incomplete, and therefore this demand was conceded. But nonetheless, it resulted into heated exchange and heated debate in the Constituent Assembly itself, and even today it is a debatable issue, but nonetheless no one can deny that it is not a fundamental right in the Constitution. Now, practice of course was also a very debatable proposition then, because practice there were some people in the Constituent Assembly who were apprehensive what is practice, because when you say that practice freedom of religion and then practice freedom to practice religion, if that is a fundamental right, then that practice can include many other practices, within Hindu society which were detestable or which were not basically advisable to continue, and therefore one of such practices was of course untouchability. Then there were many other evil practices which had disastrous consequences for women, for children, and so on and so forth. So, therefore, this practice was basically subjected to strict limitations, public order, morality, conscience, and so on and so forth. So, therefore, this is not absolute, none of these rights are absolute, they have been restricted with reference to morality, public order, lot of conditionalities have been imposed, because the state from time to time can regulate this freedom, but nonetheless people have this freedom, that is freedom of religion and conscience. And then the next type is of course, which is very significant, is the minority rights under 29 and 30. Interestingly, Article 29, the language of Article 29 does not show that it is exclusively meant for minorities, because here the word is citizens, but Article 30 is definitely exclusively meant for minorities, where they have been given the right to administer their own educational institutions to preserve their culture and identity. But nonetheless, Article 29, where you have the freedom for culture, to preserve culture, language, script, and so on and so forth, is not phrased in a manner where one can basically interpret it to be right for minorities only, but all citizens basically can have this freedom, particularly in terms of language, script, and culture, to preserve that. Now, this is another type. So, basically the 6 different types, and finally, as I was mentioning, that constitutional remedies are also available as part of this constitution under Article 32, where various types of writs have been prescribed. So, this is how we can say broadly that this is a scheme of things under which the fundamental rights can be understood. Now, this entire chapter on fundamental rights start with Article 13, as I was telling you, that which defines law, what is law, and therefore it not only defines law, but also prohibits that nothing can be done which basically takes away the rights in this chapter of the constitution. And a lot of people basically locate this judicial review power of the Supreme Court with reference to Article 13, that it is this article which gives this power to the Supreme Court. And Article 32, people feel that is only instrument through which the Supreme Court basically operationalizes its power of judicial review. So, therefore, 13 is quite important. Now, coming to Article 14, that is equality, the two provisions which are quite significant here. One is equality before law, another is equal protection of law. So, far as equality before law is concerned, it is basically a British system, whereas equal protection of law, one can say, is American doctrine. Now, of course, equality before law is something which is nothing but a rule of law, the British system of rule of law. As you know, in political science, that how rule of law was propounded by Dicey, and then there are various nuances, various dimensions of this rule of law. Now, in Britain, whether it ordinary citizens or officials, all of them are subject to this rule of law, that equality before, everyone is equal before law. Unlike France, where you have this administrative law, when the officialdom, basically the government functionaries are basically subjected to different set of laws, that is administrative law, but in Britain there is one set of law for both citizens and the government functionaries, the state functionaries. So, similar situation in India, everyone is equal before law, there is no discrimination on basis of any identity or any identity marker, and then there is equal protection of law. Basically this is American doctrine. Now, this is something quite interesting to see, that what does it mean, equal protection of law. Now, equal protection of law of course implies that application of this law in like situation, not unlike situation. So, therefore, if conditions are different, and then there is a reasonable basis for differential treatment, then one cannot say that that differential treatment is violation of this provision of equality before law. So, equality does not mean basically total absolute identity, rather classification for legislation purpose. One can say that differential treatment having a rational basis can be justified as according to or in tune with this principle of equal protection of law. That equal protection of law is there, but if situations are different, conditions are different, then in different situations one can say that different treatments are expected. But of course, there has to be a reasonable basis for differential treatment, and that can be defended objectively, that why differential treatment has been given, because the conditions are different. But in like situation, in similar situations, similar treatment, in different situations, in different treatment. So, this is basically one can say that this is the essence of this provision, that is equal protection of law. Now, after Article 14, Article 15, which is also part of this generic principle of equality, Article 15 talks of non-discrimination, that totally a state will not discriminate people on basis of religion, caste, sex, place and birth. So, these are specific words which have been used in this provision, that a state will not discriminate on these bases, and of course, no one will be basically prohibited access to shops, to restaurants, to wells and ghats. Of course, exception has been given here, and that is women and children. So, total non-discrimination, and in what sense, that also has been specified, that access to these things, and exception has also been mentioned, that is women and children. Of course, what happened, that in the first amendment of the Constitution in 1951, of course, 15 was amended, Article 15 was amended, and 15(4) was added, when the socially and educationally backward classes, state was empowered to take special measures, and this amendment was necessitated by that famous Champakam Dorai Ranjan case, in which some educational institutions, the admissions, a girl was trying admission in some educational institutions, but she was denied because there was a reservation, and then she invoked Article 29, under which this discrimination was not admissible, and therefore, this amendment was necessitated. So, 15 now stands as it stands today. So, you have two exceptions, first women and children for access to these things, that is shops, restaurants, wells and ghat, and then socially and educationally backward classes, special measures can be taken, and that will not be considered discriminatory practice under Article 15, which totally bans any sorts of discrimination. Now, 16 again is basically the continuation of the same process. If that is a non-discrimination in 15, then is the equality of opportunity, particularly that every citizen of India will have equality of opportunity in jobs and services, and therefore, this is also important provision of the Constitution. Of course, departure is also permitted here. For example, residence, on basis of residence, certain provisions can be laid down, under which some special privileges can be given, and according to this principle of departure. 1957 Residence Act was promulgated, and we know that number of states like Andhra and other provinces, Himachal and so on and so forth, they enacted on basis of this principle and made a provision for residential requirement for jobs and services. But nonetheless, this is equality of opportunity, that there will be no discrimination, there will be no basically inequality in terms of the opportunities which are available for every citizen in India. Of course, then 16(4) is equally important, and that is that for adequate representation, basically special provisions can be made for scheduled castes, scheduled tribes, socially and educationally backward classes. Now, this of course 16(4) as normally court has been trying to do is read along with article 335, where you have a clause saying that SC and ST's claim, scheduled castes and scheduled tribes claims in jobs and services should be taken into consideration, keeping in mind the efficiency of the administration. So, 335, on basis of which this reservation for scheduled castes and scheduled tribe is done, that is read along with article 16(4), where you have equality of opportunity is basically limited in favor of certain sections of society who are clearly mentioned if in the opinion of the state their representation is not adequate. Now, again the adequate is a subjective consideration, and efficiency is also a subjective consideration. So, therefore, the two important qualifications are there, and that have led to basically number of litigations, number of judicial contests and contestations of this issue, that how this equality of opportunity can be limited, how equality of opportunity can be restricted, particularly in light of provision of 16(4), when this adequate representation, in order to promote adequate representation, it is also mandated that certain positions can be reserved for scheduled castes, scheduled tribes and other backward classes. Now, another interesting thing is basically this adequate representation that has given rise to this qualitative and quantitative representation. Qualitative and quantitative representation, whether number is important or the quality is important, that is number one. Number two, that this discrimination from the very beginning basically mentions that no one will be not discriminated, that is language of 15 and continues to great extent in 16. No one will be discriminated on basis of religion, caste, creed, so on and so forth. And therefore, when the seats are reserved, when the measures are taken for reserving positions for different sections of the society who are disprivileged, then a question is often raised that on the one hand these articles of the fundamental rights section basically prohibits any discrimination on basis of caste, but how this reservation or how this positive discrimination can be based on this principle of caste. So, this is another contentious issue, and of course, recently we find that when the state tried to basically reserve certain positions for economically backward people, then of course, Supreme Court and the judiciary in general has expressed its reservation that the language of this article is not economic backwardness, but rather socially and educationally backward. So, basically economically if someone is backward, but socially and educationally if cannot be established objectively that they are also backward socially and educationally, then simply on basis of economic backwardness this article or this provision cannot be invoked to basically reserve the positions for those sections in jobs and services, in the sense that equality of opportunity can be limited or can be basically constrained, or equality of opportunity can be basically suspended only in one instance if it is meant to promote adequate representation for socially and educationally backward sections of the classes of the society. So, this is one important thing. Now, this class and caste issue is also very important. For example, whether this use of the class is caste or it is simply class, this is another debatable issue. In the Constituent Assembly, of course, it came up again and again. At one point of time, this class was not there, it was a minority, and finally it was made class. Now, of course, after a lot of judicial pronouncement, we have some idea that what this class after all implies. Now, it is basically it has been judicially established and judicially pronounced that the caste is the only basis through which this class is to be identified. So, caste is a identifier, or one can say basically on basis of, by using this tool of caste, the class is to be identified for this purpose of 16(4), or one can say the 15(4), what is there after this amendment of the Constitution, after the first amendment. So, therefore, this prohibition of caste as it occurs in both article 15 and 16, and that creates this confusion that on the one hand it is prohibited, on the other hand when for adequate representation the provisions are made, they are basically made on basis of caste. So, how it basically synchronizes with this provision, that on the one hand you are basically prohibiting it, on the other hand you are using it. But now, of course, this clarity is emerging that this prohibition is there, but in India normally the backwardness is understood as basically a backwardness in terms of social and educational backwardness, and which largely emanates from the caste basis of Indian society. So, this is something interesting to see. Now, what has happened, that another important issue which are related to this 15 and 16 non-discrimination and equal opportunity are basically the quantum of reservation, that if it is in order to promote their representation, then what should be the quantum. And it is here one should remember the famous speech of Ambedkar in the Constituent Assembly, particularly in advisory committees on minority, that Ambedkar's position was that non-discrimination is rule and positive discrimination is an exception, but the exceptions should not eat up the rule. That means that it should not be in such proportion that the basic principle of non-discrimination gets completely effaced. And Supreme Court more or less is basically has come to the same position when it has put a ceiling of 50%, that whatever measures you take, whatever positions you reserve, but attempt should be made that this total number of positions should not exceed 50%. And therefore, what happened is Mandal Commission, and after that, that famous Indira Sawhney judgment, both of Indira Sawhney judgment, which is basically also known as Mandal judgment, it has also validated the same position, that is a 50% ceiling. Now, of course, some states like Tamil Nadu and other, when they started breaching this 50% ceiling, and basically on their request the parliament legislated and started putting many provisions for reserving seats in favor of the backward sections in 9th schedule, and thereby basically shielding it from judicial review. The court said that 9th schedule is exclusively meant for those legislations which are there for land related legislations and so on and so forth. So, original structure of 9th schedule cannot be disturbed, and if some subsequent basically insertion of any act, any provision in 9th schedule will take place, the court would not basically shy away from scrapping it, because that will amount to taking away the important power of the Supreme Court, that is judicial review, and that is one of the basic structure of the Constitution. So, this is how we should understand this provision of equality in article 15 and 16. Then of course, 17 is equally important, that is untouchability, which was a source of inequality, and therefore, untouchability was abolished in unambiguous terms, and it was meant to create a equitable society. And according to this provision, the Civil Rights Act of 1955 was also enacted. And finally, article 18, that is abolition of title, is equally important, because during colonial period it was a normal practice of giving different types of titles to the people and creating the hierarchies in the society between the privileged and the disprivileged. The privileged people being recognized and basically honored by the colonial state. But this constitution, what it did, abolished all titles except certain titles, or no, one cannot say titles, but certain honors which are given by the state, like Padma Shri, Padma Vibhushan, Bharat Ratna, and so on and so forth, with a rider that they cannot be prefixed with one's name, and so on and so forth. So, this is how we have to understand these provisions of equality, which was very significant. As I was mentioning, this is not only a democratic value, this is not only important for democratic polity, but this is also important from the point of view of secular polity, because secularism, as I was trying to discuss in the beginning, stands for three things: equality, liberty, and fraternity. And this equality principle is important, then liberty principle is important. That liberty is not only the civil liberty and political liberty, but different types of liberty, the religious liberty, and so on, economic liberty, and so on and so forth. So, therefore, equality, liberty, and fraternity, and that fraternity is that how this tolerant society can be created, and that tolerance can come only when people start upholding democratic values. So, therefore, this principle of equality is important from the point of view of secularism also. Now, then we move to from equality to freedom, and this freedom is equally important part of the constitution. Well, now what happens that this article 19 has 6 fundamental liberty. Of course, earlier it was 7, but the property has moved from this section. Now, freedom of speech and expression, of course, there is no freedom of press, but now the judiciary has interpreted it in such a manner that freedom of press is basically emanating from this freedom of speech and expression. Of course, there are a lot of restrictions on this, because there cannot be absolute freedom of expression, then that can result into social disorder. Of course, this is a big issue in political theory also, that how expression and censorship can be harmonized, how they can exist together. There cannot be absolute freedom of expression. In Indian context, the restrictions which are prescribed are for security of the state, friendly relations with the neighbors, public order, decency, morality, contempt of court, defamation, and incitement to offence. All these are the basis on which the state can restrict this freedom of expression. Out of all these, 3-4 are quite important, particularly defamation and this public order, and of course, security with friendly relations. A lot of people criticize this provision, that if for friendly relations, if freedom of expression is limited, then that means that people will not have the liberty to criticize a country's foreign policy, because if country is having a foreign policy towards some other countries, and if the citizens are trying to use this freedom to criticize it, then the government of the day may basically restrict it, saying that it is basically against this friendly relations with other countries. So, this is one thing. Then this defamation, defamation particularly is normally we hear about it particularly in context of newspapers coming with some stories, and then they are taken to court for defamation, for basically planting false stories, or basically hurting the sentiments of the people. Freedom of expression also at times basically comes in conflict with decency, morality, and so on and so forth. Incitement of offence, particularly often we hear that the books and the movies they are banned in India, because at times it is believed that if they are not banned, if no restriction is put on them, then that may lead to social turmoil, and public order is one of the basis on this restriction can be imposed. So, reasonable restrictions of course is always subject of interpretation, and judiciary has been trying to do it from time to time. The next freedom is of course freedom to organize a meeting or take out processions and assemble peacefully. This is another important thing, but again this is also limited, and the restrictions are prescribed along the same line in which other liberties have been restricted. Now, then freedom to assemble, this is freedom of association. This is another important liberty, and again public order and morality, basically these are the two important bases on which this is restricted. Now, the freedom of movement, that people have the freedom to move from one place to another. Again, there are basically different provisions through which they are restricted, but two important thing are to be remembered. One is the protection of scheduled tribes, because this freedom of movement has been restricted with reference to the scheduled tribes, because they inhabit particular areas, and therefore this freedom is not absolute, in the sense that people start moving and entering in those areas which are inhabited by scheduled tribes, then their culture, their identity, their a different life and their structure may be disturbed, and therefore this freedom is restricted with reference to scheduled tribe as well, along with internal unity and so on and so forth. Then freedom of residence, again everyone has a freedom to settle in any part of the country, to reside any part of the country, but again basically this scheduled tribe clause is there, that the government may restrict it in the interest of the scheduled tribe population of the country. Then to practice any profession, trade and business, but again this is also subject to some restriction. So, this is how this freedom clause is there under article 19. Now, a lot of, as I was mentioning earlier, the criticisms are that the constitution gives freedom from one hand and takes away through other hand. This is one of the criticism, but as Ambedkar defended it, there is no constitution in the world where the freedom is absolute. They are always limited, restricted in the interest of society and the interest of the larger humanity. Now, after 19 you have article 20, and that is regarding a continuation of this principle of liberty. This is regarding preventive detention and double jeopardy, that one cannot be punished twice for the same crime. Then you have article 21, that is life and liberty, a very important thing. Even during emergency this right is not suspended, and basically now as I was mentioning that 21A has been added, where you have the right to education also, the free and compulsory education till age of 14, and therefore this right to life, this entire meaning of life has been expanded from time to time by the judiciary. As I was mentioning earlier, the dignity is now considered part of life, but now the legislature has also chipped in, and if judiciary made dignity part of life, now legislature has made education as part of life. Of course, judiciary also was trying or interpreting it that way earlier, but now after legislating on this matter, after amending the constitution, and basically this right to education, which is now made a fundamental right, there is a qualitative expansion of this provision under article 21. Then article 22, you have the protection against arrest and detention. Of course, the preventive detention is there, but then of course one is to be produced before a magistrate within 24 hours, and then even if one is arrested under preventive detention, there is a procedure that how advisory board's recommendation for 3 months is to be secured. And then of course article 23 is the prohibition of traffic in human beings, that is the forced labor. Basically this is a provision against exploitation, as I was mentioning, and this was quite significant for a society like India, which was reeling under colonialism, and all sorts of exploitations were sought to be banished from the society, and therefore this provision in the constitution was quite significant. So article 23 was the prohibition of traffic, and 24 of course was regarding the child labor, and this is one of the provision of the fundamental right, as I was mentioning, is totally absolute. No restriction accompanies this provision, that no child labor is basically allowed in any factory, rather it is totally prohibited and restricted. Now after these right freedom against exploitation, as I was mentioning, then the 3-4 important provisions are dealing with freedom of religion, basically freedom to manage religious affairs, freedom against taxation, particularly the taxation and the proceeds of which are going to be used for promotion of any religion, and therefore freedom from attendance, compulsory attendance in any religious congregation, or basically so on and so forth. So basically the purpose of article 25 to 28 essentially to create the foundation for a secular polity in India by giving freedom of religion and by making many other provisions which basically lay the foundation for a secular polity. And then 29 and 30, as I was mentioning, this is identity and cultural issues related rights, where the minorities have been given right to preserve their culture, language, script, and also to manage their educational institutions. As a minority, they have been given this right to preserve their separate identity. Of course, Article 13 as right to property, it was quite significant, but after 44th Amendment, this no longer exists there, but other provisions are still there, which were basically inserted through various amendments. And finally, Article 32, which is in Ambedkar's opinion is the soul of the Constitution, through which these fundamental rights are to be secured and preserved through number of prerogative writs like habeas corpus, mandamus, certiorari, prohibition, and so on and so forth. So, this is how this entire scheme of rights we find in Indian Constitution.
Right. Thank you so much, sir. In fact, we are extremely privileged to have a lecture which might also be pertinent to the general public, talking about the fundamental rights. So, friends, we have already had a lecture on the same, and today is the second part, and so we look forward to having you as viewers once again, and for these wonderful and thought-provoking ideas. So, thank you for watching us, and thank you so much, sir, for being here today. Thanks a lot.